Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Amy Bailey from Bailey and Terranova Attorneys at Law, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people with real legal problems. Today's episode, we're going to help you with picking your auto insurance under the new no-fault law. We will talk about juveniles in the criminal justice system and also working with the friend of the court in your family law case. Stay tuned.
In the name of family law.
Welcome to In the Name of the Law. Today we have with us Stephen Holland, the Assistant Deputy Friend of Court for Eaton County, and Bailey Terranova, a family law attorney at Bailey and Terranova. We're going to be talking about the Friend of Court and what it does. So, Stephen, if you could tell us a little bit, what does the Friend of Court do?
Well, the Friend of the Court was created by statute to assist the family court in issues related to custody, parenting time, child support, domicile issues, as well as the enforcement of orders related specifically to those issues. So that's a general overview of what the Friend of the Court is supposed to do.
So exactly how does the Friend of the Court help individual parents with those types of issues?
Well, if the parties have an open case with the Friend of the Court, they have the ability to, they're court ordered to come for a meeting before the Friend of the Court to kind of set up the basic rules for custody, parenting time, and child support. And they also have access to various employees at the Friend of the Court to answer their questions, because this is clearly a world they're not familiar with. And a lot of times I don't think they realize that they should be exploiting the Friend of the Court and the resources available by either contacting either a caseworker that may be addressing child support or an investigator that might be able to assist them with regards to a custody or a parenting time issue. And a lot of times they may not know who the individual is, but simply calling the Friend of the Court at the main office, they'll be directed to the right person.
So I think you said that the Friend of the Court was created by statute to help relieve the workload of the judges. So does the Friend of the Court resolve a lot of cases so that the judges don't have to handle it?
It does. Statistically, 5%, at least according to the data that we have, 5% of the cases in Eaton County, in our county, actually go to trial. A majority of them get resolved at the Friend of the Court level, either initially at a first meeting with the Friend of the Court, or if it has to go to a referee hearing, a lot of times the parties will decide that we've had a hearing and we need to resolve these issues before we go in front of a judge. So it's a good number. So
you mentioned a hearing with the Friend of the Court. So in that process, you'd have a referee, and there's actually parents and attorneys, if they have them, are actually presenting evidence just like they would have done in front of a judge?
That's exactly right. In fact, our judges actually prefer that the parties exhaust their resources at the Friend of the Court, not only through a meeting to try to resolve the issues on their own, but if it gets to a point where they're not able to do so, the referee hearing is governed by the rules of evidence, and it can be quite frustrating for parties representing themselves because they aren't familiar with the rules of evidence. But we take testimony, they present witnesses, and quite frankly, if they run a hearing and they want to present a witness that was available at the referee hearing but they didn't present but want to share with the judge, they run the risk of the judge making a decision saying, you're not going to add more witnesses that were available at the referee hearing. So it is a formal hearing by procedure, but that doesn't mean we don't try to exhaust solving it before we have them call their first witness.
And like you said, 95% of the cases are resolved by the Friend of Court?
Yes,
Wow.
yes.
Do you know if that statistically across the state, if there's similar data, or do you have access to that?
I don't have access to the statewide data. I know that we put on a program 3 times a year to educate parties that are just getting involved in the divorce process. It's called the SMILE program, and so we try to share with them statistics to inform them that they're more likely to comply with an order that they craft and they put together than leaving it up to either a referee or a judge to decide issues that are very important in domestic relations, namely what's best for their children.
Right. Erica, can you tell us about any misconceptions about the friend of court process?
Oh, I certainly can. When I first meet with clients, their initial reaction about friend of the court is, well, we don't want to be involved in friend of the court. We've heard horrible things about them. Well, the point of that is if the two parents can work out a schedule on their own and don't need the assistance of friend of the court, that's great. We've talked about how if a case can resolve on its own, that's wonderful. And like Stefan said, you're more likely to follow the order that you've reached on your own. But if you can't, they really are a helpful tool. They set up a first meeting to get the parents moving on a temporary order, so they at least have something to work with. And Stefan is correct. The majority of cases are resolved at the friend of the court level. I've had plenty of cases where we go to a referee hearing, and before the hearing starts, we take a few minutes and see, can we resolve this? And more times than not, we are able to resolve it. And if not, we certainly have the hearing at the friend of the court level. But people are nervous about friend of the court or think they only want to take their child support from them. But they are helpful. They help answer questions. Stefan is correct. Contacting the friend of the court directly helps people save on attorney fees. That way they can contact them, ask them questions specifically about when their support's going to be deducted from their paycheck. They don't need me to call and ask friend of the court. So really, I do find friend of the court to be a useful tool.
Great. We've heard a few terms today. I think referee, investigator. Can you help us understand the difference of the different people who are in the friend of court and what their jobs are?
Yeah, I try to break it down fairly simple because the general consensus is this, as Erica, this misconception that we are just going to make a decision regarding their children. But it starts off typically with an informal meeting with an investigator. They determine whether or not they set the basic rules up. The parties have a right to object, but they also have the ability to agree. If they object, then it moves into a more in-depth investigation. And then if there's an objection or they can't reach a resolution there, it'll come before the referee. And then we, again, as Erica indicated, will attempt to mediate it prior to calling the witnesses because a lot of times the parties are unfamiliar with the fact that they still have the ability to do this, even though it's set for a hearing. So,
right. So, and one last question. So if you already have a parent already has an order in place and the other parent is violating the order or not following it, can they use the friend of court to get that order enforced?
Very simple, yes. They don't have to file any formal documents. They simply file a written complaint with our office, and it gets directed to the appropriate person, either an investigator to interpret the parenting time or custody issue, or alternatively, they'll be directed to a child support enforcement caseworker to answer the questions.
Well, thank you so much, Stefan and Erica, for informing us about the friend of the court today.
Thank you for having me.
Thank you.
In the Name of Family Law is brought to you by Bailey and Terranova Attorneys at Law. In the name of criminal defense.
We're talking about juveniles in the criminal justice system today, and we have a team of people from the law firm of Chartier Nyamfukudza. Lizzie Carey, Mary Chartier, Marissa Vinsky, and Takura. So recently, Michigan changed the law about the age to be considered a juvenile in the criminal justice system. It moved from 17-year-old to 18-year-old. What does that mean for Michigan?
So just one fine point. It actually raised the age is what it's called. It's been in the works for 7 whole years, and actually it doesn't take effect until 2021. But before, well, I guess right now, 17 years old is the magic age when somebody would be considered an adult and could ultimately go to prison and draw their last breath behind bars for certain offenses, which now until they're 18 won't be able to happen.
So why do you think the change was made in Michigan?
Well, there's so much that we have learned about juvenile brains, and that has been, I think, a big part in changing the age in Michigan. Also, Michigan is one of the last states to make that change.
Juvenile brains are extremely impulsive. The prefrontal cortex doesn't stop developing until about the age of 25 for females and close to 30 for males. And that's the part of the brain that helps you not make those impulsive decisions. I mean, juveniles can't actually really think about long-term consequences because that part isn't fully developed.
So the U.S. Supreme Court, I understand, has a series of cases about juveniles in the criminal justice system. Can you tell us about those?
Sure. So it started essentially with whether the death penalty was appropriate for a juvenile who had committed a rape. And then it evolved, there was a case involved, so the court said no. Then it was, is the death penalty appropriate for juveniles who've committed a murder? Then is life in prison appropriate for a juvenile who's committed a murder? And that's really where we are right now. Trial courts have to look at a number of factors before they sentence a juvenile, a 17-year-old, a 16-year-old, 15, 14, to life in prison with no possibility of parole. And the Supreme Court has spoken that it is the very rare juvenile who will not be able to be rehabilitated. So those sentences should come extremely, extremely rarely when you're looking at a juvenile.
So getting really practical with the change in law in Michigan, how is that going to affect cases that were pending in Michigan or people that have been previously, juveniles who were previously convicted in Michigan?
Right now, the big change is for juveniles who were convicted of murder and sentenced to life without the possibility of parole. In that situation, prosecutors have to determine whether they want to continue along the path and argue for life with no possibility of parole, or whether they are willing to concede that the individual should be sentenced to life with the possibility of parole. And the Michigan legislature has responded to a statute where it's 25 to 40 years on the minimum for a juvenile, maximum 60 if they are able to get parole. So that's still a long time, 60 years for a 16 or 17-year-old, but it just means they have the chance of not serving the rest of their life in prison.
They have that hope.
Right, exactly, that hope. And that's actually the word that the United States Supreme Court used, the hope of release. But it has to also be a meaningful opportunity for release. It can't just be this hope that is, really not obtainable by anybody. The big category of cases right now, and we've represented a lot of juvenile lifers, is individuals who were sentenced as a result of second-degree murder. So they have life with the possibility of parole, but they're not getting paroled. And there's such a big difference in the process between a juvenile who was sentenced to life, even with the possibility of parole, and to a term of years, so 25 to 60, for example.
Well, Takura said that the new legislation doesn't go into effect until 2021. Does that mean you can't start filing motions on behalf of your imprisoned clients until 2021, or is there things that can be done now if you have one of these juveniles that were either sentenced to life without parole or life with parole?
Well, the new legislation isn't retroactive, so that doesn't change anything. So if in 1980, if a 16-year-old or 17-year-old was sentenced to life, either with or without the possibility of parole, this new legislation does nothing for them. It's really looking forward to individuals. The United States Supreme Court cases, however, do impact juveniles who were sentenced to life without the possibility of parole. That is retroactive. The category of people who we don't really have a good firm answer on is those individuals who were sentenced as juveniles to life with the possibility of parole. Those are the individuals who seem to sort of be in that forgotten category, who are actually doing more time now than many juveniles who are convicted of first-degree murder.
Wow. So let's look at the contrary. A lot of people feel like if somebody commits murder, they should serve life in prison, regardless of how old they are when they committed the crime. So what's the counter argument to that?
Well, people don't realize one of the purposes of prison is rehabilitation. We want people to go there with the hope to go out into the community and be able to be productive members of society. So with rehabilitation, we want them to be better. And what we've seen is some of the victims' families actually advocate for our clients to be released so they can provide something to society after they've been rehabilitated in prison.
And what's the cost to society for keeping juveniles in prison for in an indefinite period of time?
There's a tremendous financial cost. I mean, it's well over $30,000 on average, but as individuals get older, the costs go up.
I'm sorry, $30,000 per year?
Per year, per
prisoner.
Right. So if someone, and that's the average, it's actually a little over 30,000, but as an individual gets older, they have much more healthcare needs. So the cost goes up, 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 up. And we also know that as people get older, their likelihood of reoffending goes down because, just as Lizzie was talking about, that impulsivity is gone, right, as people mature and get older. When you look at the success rate for people getting out of prison after a lengthy period of time, but when they're older, it's high. I mean, people want to be productive members of society. They don't want to go back. There's a real financial cost, but there's also a societal cost. We are losing a lot of opportunities for individuals to be contributing members of society by keeping them locked up.
Do you have any case examples that you could share with us today?
Oh, we've got lots of cases. We represented a lot of juvenile lifers, but we have an individual who, the victim's family, it's a second-degree murder case, has been very supportive of his release. The folks at the prison, warden, people who have never, ever written a letter on behalf of a prisoner, yet because this young man was convicted of second-degree murder, sentenced to life, he still is not out of prison.
And he is a model prisoner.
Absolutely.
Well, thank you so much for sharing this information with us today.
Thank you, Lisa. And if you're interested in learning more about the issue of juvenile lifers, juvenile science, juvenile brains, check out our podcast, Constitutional Defenders. We are on cndefenders.com and any other platform where podcasts are hosted. Thanks again, Lisa.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
Welcome back to In the Name of the Law. Today we're here again with Steve Sinas of the Sinas Dramis Law Firm. Now, a while ago, Steve was with us telling us about the no-fault reform that went into place earlier this year. And today we really want to talk about how that affects actual consumers. And Steve's going to talk to us about the insurance buying options that all of us as Michigan drivers are going to have to think about in the very near future.
Thanks for having me. And so we really want this show to be informative for the viewers, right? We really want them to understand the law. And we have an extraordinary situation here where for the first time in 45 years, we've overhauled our auto insurance laws. And I've gone around the state over the last several months trying to educate the public on what these reforms mean. And there are so many different complicated aspects to the reforms. It's hard for consumers to simply understand what do these reforms mean for the insurance buying process. And so today we want to focus on that, okay? Now I want to start with this point. These reforms fundamentally affect the rights and rules that apply to a auto negligence claim where somebody's at fault and gets sued for the damages caused by the crash. And it also fundamentally affects the rights people have under the no-fault insurance law. So both types of insurance products are totally affected by this law, and consumers need to understand what it means to buy liability insurance now and what it means to buy no-fault insurance now.
And just to be clear, the no-fault insurance law is when a person is going to their own insurance company to get benefits to help them with their medical care and things, whereas the bodily, you mentioned at the third party, is where they're suing an at-fault driver for their injuries.
That's right.
Okay.
And so under the original law for the last 45 years, we would all have lifetime medical through no fault, and we couldn't sue the at-fault driver for our medical because it was covered by no fault. Now these laws change whether we have to have lifetime medical. We don't have to have lifetime medical, and that changes everything, really.
So there's been a recent development as the state of Michigan is trying to implement this new law. Can you tell us what's going on?
Yes, so part of the law is to mandate that the Department of Insurance and Financial Services, known as DIFS, D-I-F-S, that's the department that oversees the insurance industry, that they have to come up with forms to help guide consumers about what these reforms really mean. And on November 18th, 2019, the insurance commissioner issued a bulletin where they publish the forms that need to be used by insurance companies to help consumers understand what these insurance options are all about.
So you sent me the forms, and they look kind of overwhelming to me. So how is a regular consumer, somebody who drives a car in Michigan, how are they supposed to understand what they're going to have to do when they see this form?
So I should first say that the viewers should definitely go to the WLAJ website for In the Name of the Law. We're going to have a lot of resources. We're going to have the forms on the site so they can look at the forms. But I want to talk about them a little bit right now. There are two forms. There's one form for the bodily injury liability type of insurance coverage. That's for the at-fault driver claim. And then there is the personal injury protection form, which is for the no-fault claim. So I would like to start talking about the liability insurance coverage form. On the screen, the viewer will see a part of this form. And here's what's going on, is that under the law, the consumer must be presented with this form. And this form explains that they have to purchase $250,000 of liability insurance coverage for each person they injure, or for a total of $500,000 per occurrence. And if they don't want to, they then have to go through the form and acknowledge all the risks that they could face if they were ever an at-fault driver and caused injury to people. So this form will be on the site, but it itemizes that your assets could be seized if the person you injure has injuries that exceed your coverage limits, your wages may be garnished, your driver's license may be suspended. And if you see all those risks, you can then select to go under the $250,000 limit all the way down to $50,000. But you have to go through this form. And this form really makes it clear that this law totally changes the liability you face if you ever caused a crash. Like I said, under the old law, you couldn't be held liable for medical expenses. Under the new law, you can be. And so this form is trying to bring out that fact, and people now need to consider whether they should buy more liability insurance coverage because their exposure is so much greater.
Okay, and can we talk a little bit about the personal injury protection part of the policy as well?
So this form, by the way, for the viewers, the form that's on the site is a form that DIF's published that insurance companies can use, but they can also make a variation of it. So the forms you see on the site aren't necessarily what the consumers are going to be presented with. The liability insurance form is the mandatory form. So the form you see on the site, that's the form that every insurance company has to use. The no-fault form is an optional form, and they can do a variation of it. But here's the thing. There are so many complicated decisions that insurance consumers need to make when they buy insurance. They need to decide whether or not they could be eligible for anything less than lifetime medical. And people who have Medicaid could purchase $50,000 of no-fault. If you don't have Medicaid, you can purchase $250,000 or $500,000, or you can still purchase the lifetime.
But isn't that the best thing, just to get the unlimited lifetime benefits?
That's the best way I would say consumers can protect themselves and the financial risks of auto accidents, is to make sure that they have their own lifetime coverage.
So are all Michigan auto insurance consumers going to have to make these choices basically in the next few months?
Yes, and on July 1st, 2020, that's when these policies are allowed to be sold. So when it comes down to it, you're not going to face any different decision right now, but in the months to come here, you're going to get more correspondence from your insurance company about the choices. And let me make this point too. The choices don't just end with levels of no-fault coverage. Some people can opt out of no-fault coverage if they show that they have a certain type of health insurance coverage that doesn't exclude auto accidents. If you're on Medicare, you may be able to opt out. You can also buy excess attendant care. There are all these consumer choice options that make the insurance buying process much more confusing and much more difficult to navigate.
So is basically every auto insurance consumer in the state of Michigan going to be getting a call or a letter from our insurance agent in the next few months?
Well, let me be clear. The options I'm talking about become available July 1st, 2020. So what I foresee happening is in the next few months, people are going to receive mailings from their insurance companies about the reforms. They might even include some of these forms that are from the Department of Insurance and Financial Services. They may include their own information. So people are going to start hearing more and more about this. And then as of July 1st, 2020, people are going to have to face the new choices and decide what's best for them. And that's where I say the lifetime coverage on no fault is the best way to protect your family.
And if the insurance consumer doesn't sign a form, does that mean they won't have insurance coverage?
Well, the forms are required to be presented to the consumer, and I would predict that if for some reason the consumer didn't sign the form, maybe the policy wouldn't be sold, or the default options that the law mandates would take effect. So the consumers are, one way or the other, going to have to deal with these forms. So I'm not here to bore people with forms. I'm just telling them the forms are going to be part of their life and what they need to understand as a consumer.
So it's really important then to go to the WLAJ.com website into the Name of the Law tab, because we're going to have the forms there with some helpful information to help Michigan insurance consumers figure out what they need to do right now.
That's right. It's a new day, so you got to learn about it.
Thank you, Steve.
Thanks.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for being with us for In the Name of the Law. Today we had some really interesting segments, really talking about different resolutions. Takura, juveniles in the criminal justice system was your topic.
Indeed, indeed. Actually, something that people may not know about Raise the Age, that's what it's been called. While it passed with overwhelming support during this term of the legislature, it was actually in the works for 7 years. So I'm glad that we finally managed to reach a meeting of the minds and resolve this issue. Science backs up that, look, the frontal cortex isn't developed fully until somebody's 25. So it looks like we are moving in the right direction.
Steve?
Yeah, when I think about resolution and no-fault insurance, I think about all the years we've fought over changing our auto insurance laws. While I am very much opposed to the changes, I guess it's a resolution on the issue in the sense that we have new laws, and now consumers need to do all they can to educate themselves and adapt to those new laws. It's the new way forward.
And don't forget to go to the WLAJ.com website to get more information about helping you pick your auto insurance, which you're going to have to do in the very near future, right?
Yeah, we're really going to help the viewers better understand that.
Right. Amy?
Well, as we heard from Stephen Holland of the Eaton County Friend of the Court, their office resolves all but about 5% of the cases that have to go in front of the judges. And I think that's comparable in most counties. And people need to realize that they are a very helpful resource. They can resolve the issues that they have if mom and dad are unable to come to a resolution by themselves. They know the courts, they know their judges. They're very helpful in that scenario.
Well, and it's not just that they're a helpful resource, right, Amy? It's that they're a very important part of the process, and that parents who are going into the referee hearing or working with the friend of court have to understand that this is a very important. This might decide the case.
Oh, definitely.
And to take it really seriously.
Yeah,
right?
you're right. They start at the front of the court level. They don't like the investigation process. They can object, and they move to the referee level, which is what Mr. Holland was talking about as far as where you have to present your evidence, your testimony, but then they still have a chance. If they don't like what happens at that level, they can move to the court.
Right.
And I think about resolution, I think there's an adage, a good settlement or a good resolution is one where both parties leave unhappy. Now think about that, right?
Right.
You think, why would you want people to leave unhappy? Well, if both leave unhappy, that means that both thought they should have got something that they didn't get.
Yeah,
and maybe that's the essence of what a good resolution is.
Indeed.
And can juveniles plead their cases and get a resolution that they can live with, just like adults?
Oh, absolutely. And so, fine point here, though, 17 was and will continue for a short while to be the magic age where somebody is considered a juvenile. But absolutely, juveniles have that right to resolve their cases.
They need a good lawyer, though, too.
That's correct. Absolutely.
Well, thank you so much for your time today.
Thank you.
See you in the next episode.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.